Good afternoon, good afternoon, good afternoon again, folks. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. We are going back to that horrible world known as the JRC, but before we do, as always, the usual disclaimers. Pardon me. If you are unfamiliar with the Stop the Shocks campaign or the campaign against the troubled teen industry, you're going to find all the pertinent links right there in the description box. Please, in particular, take note of the article written by NeuroClastic, a small non-for-profit started by autistics for autistics. In it, they interviewed over 800 ABA professionals in regards to the JRC's so-called Behavior Modification Program. The Judge Rotenberg Educational Center doesn't want you to read this article so much. They threatened NeuroClastic with a defamation lawsuit if they did not remove it from the website. Well, folks, NeuroClastic refused. You know the drill. Please read the article. Share on all your social media. Also included is NeuroClastic's public statement in regards to the defamation lawsuit threat, as well as a link to their GoFundMe. We are crowdfunding just in case the JRC ever actually does see through with their threat. Trigger warning 1. When we discuss places like the Judge Rotenberg Educational Center or Agape Boarding School for Boys, you're going to hear vivid descriptions of and catch clips of surveillance footage of people with mental health issues and disabled people being tortured and abused. If you got young children present, please make sure to use your headphones. Trigger warning 2, this channel is marked not for kids for a reason. We use profanity on occasion and speak on dark subjects. If your child is 16 and younger and they are watching this, very obviously, parental supervision is advised. Alright, so where we left off. In allergies. Forgive me for the allergies, folks. Goodness. God, it's been getting my eyes too. It sucks. The administrative law treatise cited in one of these cases relied upon the commenter helps clarify the distinction between adjudicatory and legislative agency action. So now we're going to break it down. The adjudicative facts are the facts about the parties and their activities, businesses, and properties. Adjudicative, I know I am horribly mispronouncing that, but I didn't go to law school, folks. I went to graphic arts. You get what I'm saying. Facts usually answer the questions of who did what, where, and when. In other words, explain to me, like I'm 5, how this affects this particular case in the regards to a ban on a device that has been proven time and again to provide unreasonable risk of harm or injury. Any takers? Anybody at all? Yeah, I thought not. Let's continue. How, why, and what motive or intent? Adjudicative facts are roughly the kind of facts that go to a jury in a jury case. Oh my God. I ask myself, how stupid is the JRC every day, and how much money they must be bribing people to just completely act and turn the blind eye to their evil, psychotic stupidity? And I never get an answer. Okay. Why are we using words like that in regards to something that has nothing to do with a jury? This is not a court case. At least not this time. So why are we using these terms? It's because the JRC likes to confuse people. That's why they use such vague terminology as justification for anything that they do. Because if you just take it at surface value, and unfortunately most people do, you won't think twice about it. But so those of us who like to dig, we just kind of stare at you wondering from what pit in the 9 circles of hell was this thing birds, and how can it be so stupid and still continue to allow to go on? Legislative facts do not usually concern the immediate parties, but are general facts with the help of a tribunal decide questions of law and policy discretion. In other words, this is not judge and jury here. Okay? This is a federal department that is acting within the authority given to them in order to see through with their mandate. Okay? Alaska Airlines Incorporated versus CAB, quoting 1 Davis Administrative Law, the D.C. Circuit further illustrated the distinction with a passage from the Attorney General's Manual on the Administrative Procedure Act, 1947 at 14 to 15. I know we're kind of going through these here pretty quick, but such it is when you're going through the stupid, right? The object of the rulemaking proceeding is the implementation or prescription of law or policy for the future, rather than the evaluation of a respondent's past conduct. Conversely, education is concerned with the determination of past and present rights and liabilities, none of which is up for debate here. We're talking about banning a device. We're not relitigating the 2012 case. Okay? Normally, there is involved a decision as to whether past conduct was unlawful, so that the proceeding is characterized by accusatory flavor and may result in disciplinary action. In other words, that is not what's going on here. This is not a regular court case. Okay? This has nothing necessarily to do with action so much as it does the debate on whether this device should be able to be continued to be used to torture disabled kids. That's what this whole thing is about. We're not talking about individual actions that are taken or anything of that nature, although all of that have been litigated repeatedly in regards to the JRC before. This is about the device, period. Period. So even bringing in this terminology as though you were going and trying this as a court case, as usual with the JRC, makes absolutely zero sense. Okay? So, we go up here and that comment, citing their stupidity that it would deprive parents on whom ESDs are currently used at the JRC of the procedural protection required under the Due Process Clause of the Fifth Amendment of the Constitution, does not make any coherent sense, because this isn't a court case. This is about a banning specifically of a medical device that has been found beyond all shadow of a doubt to have infinitely more risks than benefits, and it has an unreasonable undue risk of harm or injury to the child. What even are you trying to argue here? Again, JRC, for the love of God, please put down the crack pipe. All right. We're going to read this last paragraph here, and then we're going to close out for this one. The object of the rulemaking proceeding is the implementation or prescription of law or policy for the future, rather than the evaluation of a respondent's past conduct. Okay, we've kind of gone over this a little bit. Conversely, education is concerned with the determination of the past and present rights and liabilities. Normally, there is involved a decision as to whether past conduct was unlawful, so that the proceeding is characterized by accusatory flavor and may result in disciplinary action. In other words, I'm rereading this because none of this applies here. Literally, none of this applies here. It is another case of what even is this argument? And why does the poor FDA have to even go through all of this to combat it? We're going to go ahead and close on that before my brain explodes. We don't get very many views on this channel. The few we do tend to get removed from time to time. Folks, you do know the drill. Please don't forget to hit the like button, hit subscribe, and please don't forget to hit the comments. I appreciate your time. And as always, folks, we here at Spilling Tea do hope you have a good one. I'll see you all in a few minutes. Bye-bye, everyone.